everyone. It's wonderful to see you all. Thank you for coming. I'd like to welcome you to on behalf of the History Department and the Lepage Center for History and the Public Interest, I'd like to welcome you to our History and the Law event, where we're going to hear from a few experts about the fascinating and interesting relationship between history and the law. Before we do, and before I get started with the fun stuff in the program, I just want to say a few thank yous, first of all. I'd like to thank the Lepage Center for sponsoring this event, along with the Department of History, specifically Dr. Paul Rozier, Kevin Fox. I'd like to thank Dean Adele Lindenmeyer and Dean Mark Alexander of the College of Liberal Arts and Sciences and the Charles Widger School of Law, respectively, for supporting this event. We're really excited. In addition to hearing from our panelists about the way that history and the law are connected, this is our first event to really kick off this new program that we have, the pre-law concentration for history majors. We have lots of information about it. I'm here if anyone has any questions. But as you'll see tonight, I think there is this really close connection between history and the law. We're going to discover the ways that legal precedent affects political, social, cultural, and economic history. We're going to look at how rulings and the judiciary are intimately entwined with the historical moment in which we live. And I think from the idea of the pre-law concentration, what we've discovered is that studying history is the perfect segue to becoming a successful attorney. The things that we do in history classes are the things that lead to success in law school. We search for evidence, we engage in critical thinking, we do a lot of reading, we interpret the facts, we interpret evidence, we engage in expository writing, we create clear and coherent arguments to try to advance our positions. All of these things are connected with success in law school and in the legal profession. What we've done with the pre-law concentration is we've tried to take the guesswork out of it for students who are interested in pursuing a career in law. Instead of asking you to find courses that might give you a good grounding in legal history or just the law in general, we've tried to curate a group of courses for you in both history and in other disciplines. The program is interdisciplinary, so you get to explore things like human rights, the history of human rights on the international stage. You get to explore the way that civil rights have functioned in American history. You get to see the way in history courses that the law has been instrumental in issues of democracy and authoritarianism and revolutions around the world. You also, in courses that have the pre-law attribute in political science, get to explore things like the constitutional law and the Supreme Court. In communications and peace and justice, you can take courses on the rhetorics of hate and social justice. There's philosophy of law. The list goes on. And so what we try to do every semester is create this list of courses for you. So if you're interested in pursuing a pre-law concentration, or if you are looking into a history major, I'm happy to talk to you about it. Again, my name is Lynn Hartman. I don't know if I mentioned that at the beginning. If I didn't, I am. And my office is on the 4th floor of the St. Augustine Center. So I welcome you to stop by anytime you like. Before I turn it over to our eminent panel, I'd like to welcome and thank Susanna Warren, who's the Associate Director of Admissions for Villanova's Law School, who has agreed to come here and share a few items and thoughts about what admissions officers are looking for in law school applications. So.
Hello, everyone. So Professor Hartman asked me to speak very briefly on what schools are looking for in its applicants, and I'm happy to elaborate afterward on what some of those things may be, whether it's at Villanova Law or any law school, what they're looking for. But it was a big question. There's a lot of different parts that go into applying to law school and what law schools are looking for, because there are, I guess, over 200 in the country, slightly 2 to 2:05. So they're all looking for different things. Most law schools are going to counsel you on a holistic review of like approaching the application. So there are many, many things that law schools look for, from LSAT and GPA, which is something they very heavily weigh, all the way from community involvement, volunteerism, anything like that that is going to kind of give us an idea of your passions and your motivations for wanting to attend law school. But they look at everything: work experience, community service, the list goes on and on. I just wanted to let you know that it's not an easy question to answer, but I'm happy to answer it for anyone who has very specific questions about what law schools are looking for. But ultimately, what they're trying to determine is like whether your undergraduate and graduate work, if that applies, your work experience beyond your academics is going to hold up to the rigors of their program, and whether they're a good fit for you. So whether or not they're offering the programming that you need, the practical experiences, the extracurricular activities that you can do in law school. Law schools are trying to look at that and see whether it's going to be a good fit for you, as well as whether you're a good fit for the community. So just keep all those things in mind. I'm happy to go into any details about it, but and there's some information right outside about our specific law school. But let us know if you have any questions. We do have an information session that is virtual and coming up on March 20th. So if you want to sign up, just let me know. I'll be around. Thank you.
Okay, so before I turn it over, there are a few more, in addition to forgetting to tell you my name in the beginning, and then I'm chair of the Department of History. I also forgot to thank the people who make this, a lot of this possible, and that is Vicki Sharpless and Franny Murphy from the Department of History. In addition, Kevin Fox and Cole Hearing, Ryan Snyder from the Lepage Center, our wonderful workers in the History Department, Kate and Colleen, who are here today to help make this a success. So I just want to make sure that I say a very sincere and hearty thank you to all of you. And with that, I'd like to turn things over to my colleague, Dr. Elizabeth Kolsky, who will introduce herself and the panel.
So I'm going to introduce our 3 panelists. Each of them will speak for about 15 minutes, I think, a little less, and then we will open the floor to questions. So please, as they're speaking, take note of questions or thoughts that you have, and we will be sure to get to them. So our first speaker is Ellen Ratigan. Ellen is Assistant General Counsel at the law firm Dechert LLP in Philadelphia. In this role, Ellen creates and implements risk management and compliance procedures, advises on legal and business issues involving policies and internal controls, and handles ethics and professional responsibility matters, subpoenas, and other legal issues involving the firm and its attorneys. Woo. Ellen was previously a litigation associate at Dechert, handling litigation at both trial and appeals courts and government and internal investigations. She also has substantial experience in pro bono work, including arguing 2 civil rights cases before the Third Circuit and representing clients in other civil rights and habeas corpus cases in the federal courts. Prior to joining Dechert, Ellen clerked for the Honorable D. Michael Fisher on the Third Circuit and the Honorable J. Curtis Joyner on the Eastern District of Pennsylvania. She received her BA from the wishful thinking. From the University of Pennsylvania, majoring in history, and her JD from the University of Pennsylvania Carey Law School. Our second speaker will be Professor Abel Garza, who is an adjunct instructor at both the Villanova University Charles Widger School of Law and the Villanova University College of Liberal Arts and Sciences. He holds both a Bachelor of Arts and a Master of Arts in History from the University of Texas at San Antonio, and a JD from the Villanova University School of Law. He practiced law at an Am Law 100 firm here in Philadelphia and provides pro bono legal services through Philadelphia VIP. He serves on the board of directors for the Villanova University School of Law Minority Alumni Association, and he was recently elected to the Philadelphia Bar Association Board of Governors. And our third panelist today is Professor Jessica Webb, who has been a professor of law at Villanova since 2013. She teaches American legal history, amicus advocacy, an advanced appellate advocacy course that incorporates the Theodore L. Reimel Moot Court competition, which she designs and administers. Before joining Villanova, she practiced law at Blancrome LLP, Rubin, Fortunato, and Harbison PC, and Post LLC. Her scholarly interests include judicial decision-making throughout American history, the history of oral argument, and the continued relevance of oral advocacy to appellate practice. So we'll start with you.
Okay. So I'm here, I think, to provide the practitioner point of view. I've been out of law school for, I guess, almost 12 years now, and I did 2 clerkships on the trial level and the appellate level right after law school. And then I've spent the past 10 years at my law firm, Dechert, which is one of the big law firms in Philadelphia. I was a litigator for about 5 or 6 years, and then I've been assistant general counsel, which is basically the lawyer for the lawyers, for the past almost 5 years. I was a history major. I went to Penn. I love Villanova, but my mom is Dean Lindenmeyer, and so it would have been a weird situation for me to be a history major in the department that she was the chair of at the time I was in college. So I went to Penn, and then I also went to Penn Law School. I did work for 2 years in between undergrad and law school, and I think having gone to law school after having had a working experience was really good for me. It gave me a lot of perspective and really made me sure that it was something I wanted to do instead of just not really knowing what I wanted to do. So that's something I'm always happy to answer questions about too. But I really think that being a history major, for me at least, was really a perfect fit for then going to law school and becoming a lawyer. I think that's particularly true in the litigation field. And that's because everything I did when I was a litigator and a lot of what I do now is a good fit on the skills that you learn when being a history major. You are learning analytical skills, reading comprehension. You're doing a lot of reading. You're doing research into various different sources. When I would write a brief, I would be going to different sources, essentially, different sources of case law, secondary sources, all that sort of thing, and then putting together the pieces, much like you would in a history paper, putting together the pieces of the argument, your thesis. And I would say when you're a lawyer, you have to add on the advocacy that is somewhat missing from when you're being a historian, but you're really sharpening those skills when you're a history major. And for me, when I was in undergrad, I didn't think or know that I wanted to be a lawyer, but some of the most useful classes that I took in undergrad for when I arrived at law school were ones that really made me do independent legal research, where I had my own project and nobody was telling me this is what you should be looking to and this is what you should be writing about, but I had to take the initiative to carry through my research, through the thesis, through, the paper that I was writing. And so for me, that was in doing my thesis. I did a thesis through my history undergrad, and I think the skills that I learned in that translate almost perfectly to a lot of the skills that I had to have to be successful in law school. And then those skills also translate through to clerking after law school. When you're a law clerk to a judge, your job is to research and provide guidance to the judge that you're working for. And so you're using those same skills of research and a lot of writing to do that. And then when I was a litigator, same thing. I mean, there would be days where all I was doing was sitting in my office and researching and writing. And then there were other days where I would be, going back and forth with other attorneys on the case and trying to sharpen arguments, develop other skills as well. But especially in the litigation areas I was doing, the researching and writing was so important. And then even what I'm doing now, which is more advisory work, I don't really write briefs anymore. Still, what I do every day, and what a lot of lawyers do every day, is people come to me with questions, and I figure out how to help them under the confines of the rules of professional responsibility mostly, because that's what I'm mostly concerned with, is legal ethics. And so I'm still using those skills of going back to the sources, right? For me now, that's the canons of ethics and the commentary, implementing them, and the case law, interpreting them, and then using my analytical skills to apply that, the situation onto the legal ethical canon. So that's, my take on how the history degree really helped me. And I think there are other majors that you could do that would be helpful too, but I really think for law school and particularly for a litigator, they're a really good match. And, just being interested in that area of the world too. Like if you're interested in law school, you're going to have an interest in some of the areas that a history degree will help you, like politics and, the Supreme Court, what's happening with the rule of law, that sort of thing. There's just an intersection of them both. So I'm happy to answer any questions about what I do and the skills that I've learned, but that's my narrative. I'm sorry, that's not 15 minutes. But I think questions are better suited for me.
Lawyers are taught to be straight to the point.
Yes, exactly.
Thank you. It's so interesting because I echo her comments and Dr. Hernandez's comments when it comes to the benefits of learning, studying history and its application to the law. I remember when I was in the graduate program at UTSA, getting my master's in history. My goal was to get a PhD in history. And one of my professors, my mentors at the time, Dr. Patrick Kelly, pulled me to the side and he said, Abel, I think the law, studying the law or going into legal practice would be really good for you. And I thought one of two things, either he's trying to get rid of me or he really knows what he's talking about. And we talked about it a little bit and he basically summed up what was said, that the study of history is not so different from, the study of law and the practice of law. You do research, you create conclusions, you try to support those conclusions with evidence and your own interpretations, and you make a theory, you make a point. That's the same thing when it comes to practicing law and you're presenting an argument to the court, is you are taking one position and you are going through a whole bunch of case law, which is your sources, right, your evidence, and you're trying to use that law to make a persuasive argument that you can have the judge agree with you. And I think understanding history kind of puts you in a better position of, what to look for as far as argument-wise in order to find arguments that are persuasive. In the class that I teach, American Legal History, at Villanova undergrad side, we look at legal cases from a historical perspective. So, for example, today we're looking at the effect law and the Supreme Court have had on women's rights. Last week we looked at the effect they've had on Native Americans. And so we see the evolution of how policy has shifted through the eyes of the law, right? So it's not just understanding, the court decided this, issue for this reason. It's like, well, what was going on in the background? What's the historical context? What was going on socially? We get a better glimpse of what was going on during life at that time period. It gives us a better understanding of, okay, I have an idea on why the court sided with this party as opposed to that party. I may not agree with them, but I have a better understanding. right? Because one way or another, we're never going to completely agree with what a judge or Supreme Court may say because, we're human. But one of the good things about studying history is that when it comes to, for example, the Supreme Court and them determining, what legal arguments to analyze and how to view things and how to view persuasive arguments, they view different factors that are very relevant to history. They look at judicial precedent, right? This concept of stare decisis, where you look at prior case law in order to determine whether you are on the right track, whether you should continue down the track. Is it better for society to continue down this path, or should we deflect? And in that case, is there enough valid reason for us to deflect? There's also, the intent of the law. What was the intent of the law? What was the intent of the framers? We see this all this time. The court analyzes these perspectives. We saw this in one of the most important cases that came up in the 21st century, which is District of Columbia versus Heller, where the Supreme Court decided whether, gun rights was a constitutional protected right or not. Here in this case, you had both sides present arguments, and both sides presented their arguments on the interpretation of the Second Amendment. We had an individual interpretation, we had a collective rights interpretation. And they both presented arguments and documents concerning constitutional texts, founding fathers' papers, state laws, and just other historical texts. And using that evidence, the court was able to kind of reach a great conclusion in finding what was best situated for the country. Again, we may not agree with the ultimate decision or not, but it's up to the court to determine whether, the decision fits the historical and societal construct of our time, right? Because the Constitution is always evolving. Another thing that history teaches you is to analyze social norms, social trends, which I think is very important when understanding the law and making a persuasive argument for your party. So another case that really resonates with that concept is Obergefell v. Hodges, which was the case that found that same-sex marriage was constitutional. There, the court looked at, where is this country headed in the aspect of same-sex marriage? What is the impact on families? What is the trend among states, laws and legislatures and laws are passing? And after analyzing various social norms and trends, the court decided that it would be best, in the best interest of the country, to move in that direction, right? And then we also look at kind of history and tradition of this country, right? It's so important, and the court puts so much emphasis when determining whether a law is constitutional or not, whether to find a right constitutional, to look at the history and traditions of this country. One of the most transcending topics of this time is, abortion rights. In 1973, in the case of Roe v. Wade, you had Justice Blackmun, who analyzed various historical contexts of laws, abortion laws, how those laws treated women, was abortion criminalized, how was abortion treated prior to the creation of this country in English common law, and so on and so forth. And after analyzing all these facts and details and laws and documents, the court concluded that one of the factors the court used concluded that, women should have a right to abortion based on the history and traditions of this country. Interestingly enough, in the Dobbs case, which came out, last year, which overruled Roe v. Wade, that Supreme Court also examined history and tradition, but only to come out on the other end, right? So the Supreme Court in that case, Justice Alito noted that when a right is not explicitly listed in the Constitution, in order to find whether there is a right or not, you have to look at the history and tradition of this country. And just to put it specifically, it must be deeply rooted in this nation's history and tradition, right? Something that we saw the 1973 court find in Roe v. Wade. Yet here, Justice Alito in the Supreme Court analyzed the history and traditions of this country and yet came up with a different conclusion, right? They came up with a conclusion after analyzing different laws and different traditions and different histories, analyzing the fact that, no, wait, there were criminal abortion laws that existed in the 19th century and possibly even the 17th century. The fact that it existed shows that the right to a woman's abortion isn't deeply rooted in these history and traditions. Therefore, the prior court was wrong in coming to that conclusion. And so, because the right to an abortion is not founded and concrete in this nation's history and traditions, it is not a constitutionally protected right. So, what I'm trying to say is history is very important because the law and history are interconnected, especially when we're dealing with constitutional legal issues. The court specifically gives credence to the fact that if we're trying to create a new constitutional right, there has to be a basis for it. And one of the bases is history. And taking these legal history classes will give you their context and idea on how to pursue certain legal arguments and hopefully make a persuasive argument to the court ahead of time. It's one thing to just know the law, right? It's another thing to know why the law was created, what was the context, what were the social norms and trends at the time, and what was the legal precedent surrounding that law. Understanding those factors gives you a bigger picture, a better understanding to make, again, a coherent legal argument that will hopefully be, if you ever become a lawyer, a winning argument.
Hi, everybody. I'm Jessica Webb. It's great to be here. I have to tell you, I left to come here. It was like a half hour in advance because it seems like main campus is like a world away from the law school. I'm like, oh boy, I better set out like to get over here. And it was like 5 minutes later I was here. So the law school is not that far away. It seems like it is, but it is not. Close by, so do come visit if you have any questions after this presentation. Thank you for inviting me here. I'm really excited to be here to talk about one of my very favorite topics, which is American legal history, of course. I think at the outset, and I'm going to stick to I'm going to give kind of a mini lesson here in talking about, the development of the law in different time periods and in American history. And then also how the historical period influenced the judicial decision-making process. And so I'm also going to touch on some more current issues to discuss how history is influencing those debates. So to pick up on some of the same themes that Professor Garza also talked about. But I think it's really important, not only for those of you, which there may be some of you out there who are aspiring academics, that you want to do what we do. But I was a practicing lawyer at one time, long ago now, but I can vouch for the fact that, these issues, what we learn in history is very much relevant to the practice of law, particularly those of you who are, I would say, especially interested in social justice and policy type of issues. Those are, kind of the issues where the historical context comes in really handy when you're crafting your arguments. And just at the outset, one of my big interests is the judicial decision-making process. And we have this idea, that judges objectively apply the law. Like, as Chief Justice Roberts said of the Supreme Court, justices were umpires we call balls and strikes. Okay, that's what we do. Like, it's a formulaic process and so forth. And it's true that for a lot of controversial cases, and most cases that come before the courts, and particularly appellate courts, are not controversial. And it's possible to simply apply the law to those cases in a relatively formulaic way. But it's, courts throughout our history, and what we see, by learning history, is that they've been unable to avoid burning legal questions. And, we're seeing that now. And so in those cases can't be decided by using formal legal rules. They simply can't. And so, as one scholar put it, in those kinds of cases, the idea that judges can just purely be objective and apply the law like it's a formula is an illusion. Okay, so what then happens? What happens when you can't apply the law like a formula? Well, then the judge's own personal predilections, prejudices, and personal experiences come into play, into the decision-making process. What informs the judge's prejudices, personal predilections, and so forth? Well, the historical context in which that judge lived, right? So that directly informs the law that the judge is then creating. As Justice Oliver Wendell Holmes said, you know, he was a justice over a century now, but one of our most eminent jurists. He said the law embodies the story of a nation's development through many centuries. So in other words, what he meant by that was to know what the law is today, we have to understand what it has been. And how do we understand what it has been? Well, we do that by consulting history. So I want to go through, you know, with that kind of backdrop, like a few examples of this throughout history where the history, you know, of the historical debate has influenced current debates and current issues that are currently before our courts. I don't know how many of you are familiar, like, with the, you know, United States Constitution and the debate about the role of the federal government that surrounded the ratification of the Constitution, and in the years of the early republic following, so the decades following the ratification of the Constitution, there was a big debate. The Federalists arguing, no, we need a strong national government. We saw before the Revolution, like having just a confederation of states did not work. Been there, done that. We need a strong central government. We had the anti-federalists on the other side, which became, of course, the Jeffersonian Republicans, saying, oh, no, we're not going to have an elected monarch, okay? We've been there, done that with King George, and this is precisely why we broke with England, right? This is why we got away from that. We need to keep power local. We need to keep it in the hands of the states and so forth. So they preferred that the power then be in the hands of not only the states, but also the local governments. And John Marshall, who was the 4th Chief Justice of the Supreme Court and considered by many scholars to be the most influential justice in our history, and I would have to agree with that assessment. He was on the Supreme Court when this debate was raging. So in the early decades of the 19th century, he was a steadfast Federalist. And a lot of that came from his personal experiences. He fought in the Revolutionary War. He saw the problems that arose when you have a national government that, you know, the war wasn't being funded. Washington had trouble getting troops and so forth, and Marshall saw all of that. And so he was a big advocate for a strong federal government. Well, what happens when he's Chief Justice on the Supreme Court? He decides a little case called Marbury versus Madison, which asserted the principle of judicial review, which essentially said that the judiciary has the power to decide which of the nation's laws are constitutional. All right, so before this, the judicial branch was not a co-equal branch of government, okay? Marshall made it a co-equal branch of government. He also solidified the power of Congress. Under the Commerce Clause and the Necessary and Proper Clause. So he greatly expanded federal power in a way that is reverberating even now. Let me give you an example of how this exactly is playing out. Maybe you've heard the debate like with Texas that is trying to, you're probably familiar with this? Texas asserting its right to legislate in the realm of immigration because it's obviously a border state. So it's been having a battle with the Biden administration on several legal fronts, okay, about this issue. You know, the Biden administration claims on the other hand, no, immigration is governed by U.S. laws and the United States Constitution. Texas, you do not have the right to usurp federal authority when it comes to this area of the law. And in fact, during oral arguments in one facet of this case last week, a district court judge in Texas noted that, look, if we rule in Texas's favor, then that means like every state is potentially going to have the power to enact its own immigration and deportation laws, and what's going to happen then? That we're going to turn, he said, that will turn us from the United States of America into a confederation of states, and that would be a nightmare. Okay, he said. So, what are we looking at? Precisely the Federalist arguments that were made in the early Republic, and that Marshall, you know, being Chief Justice of the Supreme Court, solidified federal power at that time, but the debate isn't over, and it's still being made, and lawyers in these cases are still arguing the same issues, okay? Another area where I think, you know, as I was thinking about this, and I could use so many examples, I'm just picking a couple here, where knowing history is so critically important to lawyers, and that's the area of civil rights. And, you know, particularly when it comes to education, something that we're all grappling with now, a recent Supreme Court decision. Of course, in Brown versus Board of Education, the Supreme Court, ruled that separate but equal is unconstitutional when in schools, right? Thurgood Marshall, another one of our most eminent powerhouse jurists, he argued against school segregation brilliantly in that case. And in fact, he was a civil rights lawyer, and he had used the courts for years to dismantle segregation, often at great peril to himself. He was going down south and advocating for this, and you can imagine the death threats and so forth. He then became the nation's first Black Supreme Court justice. So obviously, his opinions about these things were formed from his own personal experience as a Black man in America when Jim Crow was alive and well, and also his experience as a civil rights lawyer. And so when Marshall was justice on the Supreme Court, the court decided the Bakke case, which ruled that racial quotas were unconstitutional. In his dissent, Marshall traced the 200 years of discrimination against African Americans in this country, from slavery all the way through Jim Crow and the legacy of Brown, and how that implicated affirmative action in higher education, all based on history. And he also, argued that the current situation at the time Bakke was decided, which was 1978, lent itself to a conclusion that the Constitution would not stand in the way of remedying this past discrimination. So fast forward now to last summer, June 2023. I think Susanna is familiar with his opinion. The Supreme Court struck down race-based affirmative action in college admissions last June. Okay, and both sides in that case claimed that the legacy of Brown and the history surrounding it supported their positions, their arguments in those cases. And so history was crucial to the parties' arguments. It was, embedded in the court's decisions, and including in Justice Sotomayor's powerful dissent, which was joined by Justices Kagan and Jackson, echoed Thurgood Marshall's dissent in Bakke by tracing the history of discrimination in this country, and the fight for equal educational opportunities. So strictly speaking, that decision only directly applies to college admissions, but it still remains to be seen what is the implications for the employment law context, right? Like affirmative action. So those arguments are still going to be made, and they're going to be based on, of course, the history involved. My last example here, civil liberties during wartime. We know that civil liberties, or maybe we do or don't, are often repressed during wartime. And that's frequently because wartime creates fear, and that's understandable to some degree. And so then, as a consequence, civil liberties are suppressed. But what we know, what lawyers who know their history know, is that the peoples whose rights are often suppressed, unfortunately, are innocent civilians. And we've seen this time and time again throughout our history. The Civil War. Lincoln suspended the writ of habeas corpus at least 8 times, he did it 8 times. And as a result, under this authority, military officers arrested and imprisoned as many as 38,000 civilians without judicial proceedings, okay? During World War I, the Sedition and Espionage Acts severely curtailed First Amendment rights, allowed the government to target virtually anyone who opposed the U.S.'s involvement in World War I, and the Supreme Court upheld that in the Schenck decision, said Congress has the power to do in wartime what it wouldn't have the power to do in times of peace, okay? World War II, the most egregious example. After Japan attacked Pearl Harbor in 1941, FDR signed an executive order that was understood to allow Japanese Americans to be forced to leave their homes in the American West and be transported to internment camps without formal charges or hearings. Many of them lost everything. They had to stay in the internment camps in these really pretty awful conditions for up to 3 years. The Korematsu decision, there the Supreme Court upheld the president's action in that case. We later apologized for it, but not for decades afterwards. In Vietnam, during the Vietnam era, the court kind of swung back in the other direction and was more on the side of, First Amendment rights, and ruled against Nixon's claim of national security when it came to the Pentagon Papers, which of course traced the United States involvement in Vietnam. But then we have the war on terror after 9/11. And, it's been a mixed bag. A lot of scholars claim that the court is still too deferential, to the executive's claims of national security when suppressing civil liberties. And these fights are still ongoing. They're still ongoing. Drone attacks and, what authorization, if any, does the president need in order to continue to conduct them? Well, lawyers who have a knowledge of this history of suppression of civil rights in our country are going to be able to make these arguments. There's going to be a depth of the argument, and also they're going to be the cooler heads that prevail when there are issues where fear is kind of dominating law and policy. So I hope you can see that I really do feel strongly that history and a knowledge thereof is really central to the debates that we continue to have today. I hope I didn't overstate my welcome.
By the way, every case you talked about is taught in my class.
And then come up to the law school and take mine.
So we would love to take questions from the audience, especially student questions. Any students in the audience who have a question? Yes.
This is Kolsky.
Hi.
So I've heard a lot of mixed reviews on taking a gap year or gap years in between undergrad and law school. I've heard, go through the whole thing, get it done. But I've also heard that experience obviously elevates the law school experience. So I was just wondering kind of thoughts, feedback on that.
Well, I'll take it first since I brought it up. So I can only speak to my experience, but I just know I wouldn't have been fully committed and prepared for the rigors of law school if I hadn't been out in the world and was able to really commit myself to knowing that going to law school and doing well in law school was what I wanted. I think back to my peers in law school, and there were certainly some people there were a lot of people who went straight through. And in terms of people who did well, there were certainly plenty of people who went straight through in that category too. But I really felt like taking the break and making sure it was really what I wanted was important. I mean, it's a little bit of a cautionary tale, but there was one woman who went straight through in my law school class who at the end of her first year was like, oh no, this is not for me. I just sort of did this because I was deferring making a decision about what I wanted to do. And good for her for realizing that and leaving after her first year. But as a result, she was still in debt. I mean, I don't even know how much because she did still do the first year. So it's less, the gap year provides, I think, perspective, and it provides skill, and for me it provided work ethic, but I also think it really solidified my views on what I actually wanted to do, and that's the most important part of it. So what I would caution most against is going to law school because you don't know what else to do. And I see some nods over there. Yeah. So that's really what you don't want to be doing. And for me, the gap, and I think for a lot of my friends in law school too, the gap really provided that ability to think about what you wanted to do.
Yeah, I think it depends on what it is you're going to do during that gap year. Are you just going to lay at the beach somewhere and just relax and do anything, or are you going to do something practical or some type of employment? So, I worked during, excuse me, while getting my master's and a little bit after that as well, and I was different from all my other classmates who had gone straight through. And it gives you a different perspective, but it also makes you marketable. When you're going to interviews and you're talking with people and, you're sharing about yourself, well, you have something to talk about. Perspective, you have some real world perspective that you're able to share that kind of separates you from the pack. Compared to, the majority of students straight through. I'm not discouraging that, I'm just trying to give you reasons why maybe a gap would be a positive thing to do.
I'm not sure I agree with everything that they said. I'm not sure I have much to add.
Questions? Yes.
I'm sorry, I forgot your name first. You said you did.
Ellen, yeah.
Sorry, Matthew. You did 2 civil rights, I think, cases. I've been deciding on the fence of learning more about civil rights, especially in the law field. But does it give you, or did it give you, like enough salary to, I guess, provide for a family? Because when you think of law, you really think of business law or like corporate law. But like civil rights, you don't really hear much about it when it should be, I guess, really talked about more.
That's a great question. So I have been at a large law firm for my whole career, except for when I was clerking. But what I was doing and what many large law firms do is something called pro bono, which is where we provide legal services for free for certain categories of organizations or people, that sort of thing. So pro bono legal services are a great way to get experience and to provide that community civil rights impact while still, in my case, working at a law firm that did support a family. And at my particular law firm, we have a really big commitment to pro bono, and there are certain law firms who also share our sort of higher level of commitment. Any case that I take on is, once we take on the case, I give it the same attention and same resources that I would give to a billing client. So the fact that the client isn't paying and that we're performing the services pro bono just doesn't enter into the equation. And so for me, working at a large law firm, but one that had a really robust and supportive pro bono practice, provided the best of both worlds, because I was able to take these civil rights cases through, they were both appeals actually, and we actually partnered on one of them. We partnered with a law school and worked with a law student who helped develop the arguments and, and helped write some of the briefing and that sort of thing. But we were able to take it through the appeal, and on one of them, one we lost. One I won though, and that one was a prisoner civil rights case. It was a retaliation case where the prisoner's radio had been taken from him in prison in retaliation for him, raising an issue about some other treatment in another area. And it was very satisfying to get that reversed, because there was it made good case law. Is one reason, but also it had a very real world impact for this person. And I've done a lot of across the 10 years I've been at my firm, I've done immigration cases, I've done education cases, civil rights cases. So there are ways where you can have that civil rights, that individual impact, while still working in the confines of a law firm.
Yeah, I just want to add one thing. So first of all, I think you have to decide what's more important to you, right? Is it fighting for that cause at that moment in time, right when you get out of law school, where it's like, oh, I got to pay my debt, because nobody's going to fault you for that, right? Law school is expensive. But also, having worked at a big law firm, one of the benefits of doing pro bono, which I did landlord tenant, worked for the PSPCA and did immigration work, is that you have the resources of a big law firm to help you pursue whatever cause it is. And it's not like they're dictating, okay, this is what pro bono case you're doing. They let you choose what you want to pursue and then back you in order to help you accomplish your goals. So that's one of the positive perspectives of going at it from a big law route.
Thank you.
Yes.
Hello. I was wondering if you could speak to, in your own experience, the competitive nature of law school, because, or is it competitive? Because I feel like here at Villanova, it's a pretty collaborative environment, and I was wondering, in your own experiences, does it kind of the same or differ?
So this is something I feel very comfortable speaking about. I have to say, I mean, I know as a professor, I'm only seeing so much. I don't have any illusions about that, like what might be going on, but I've been there long enough and I've worked very, very closely with students, and particularly because I run a moot court competition where we get prestigious federal judges coming in to judge the students. In other words, it's extremely high pressure. I cannot tell you how impressed, really, virtually without exception, in the 10 years that I've been doing that, how collaborative and supportive the students are of each other. Like they go through the process instead of, trying to cut each other down. It's like, I made my new best friend through this competition. I mean, that I just see that happens time and time again, that, I think the values of the school, this is not lip service, like this is real, and I see it all the time in the law school. And I can't speak to, because I went to law school at Villanova also, so I can't, and that was my experience as a student, I can't speak to other law schools and what the difference might be, but I can speak to the Villanova law experience.
I'll just say, when I was applying to law school, it was really important to me to avoid that. And there is a lot of digging when you have the slate of law schools that you are thinking about applying to, and then eventually what you've been accepted to. You can find out reputationally whether they're on the more competitive end or less competitive. One of the reasons I chose Penn was because it is on the less competitive end. Penn Law, at least I think it's still true, but we didn't have GPAs, we didn't have class rank, and you didn't know where you fell in the class at all until you showed up at graduation. So that removed a lot of the competitive elements, because okay, I got an A- in this class, but I don't know where I fall with respect to the rest of my peers. And so there are signals that I think a lot of schools put out, and ways that you can evaluate how competitive they are. Also, the school, there's always going to be a couple of people in the class who are going to be competitive, and I think the best you can do is just tune them out. That's what I did.
Sure. Echo Professor Webb's comments. I went to Villanova Law as well. Great environment. People are very helpful. It wasn't very cutthroat. Like she mentioned, you're always going to have gunners. You're always going to try to, do whatever they can to be at the top. But my experience at Villanova, and I can speak to other law schools, was a great experience. And everybody was helpful, and they would help you by giving you outlines to professors' classes. And I think the fact that, they treated you that way, you treated the class that way, it kind of creates this positive cycle. But I think the most important thing is just to do that research, because you're always going to find some schools are just have different personalities than others.
Yes.
I was wondering, in your experience, in undergrad, is there anything, outside of academics and being a history major that you did that, helped you be better prepared for law school, or helped you get a better chance of, getting accepted?
Being a history major is the first necessary step. And then the next step.
I mean, mine's going to be very practical. LSATs is huge, and take it seriously, and take a course if you can, and that's a big part of it, I think.
Great LSATs and apply to a lot of places.
Yeah, I mean, I feel like I should hand it over to this question. I mean, I think I agree. I mean, those two metrics are really, really important. And I think having demonstrated interest and leadership, I think just like with the college applications, is important in law school as well.
Yes.
Would you say the style of classes and learning, how does it differentiate from an undergraduate degree?
So a lot of the first year classes are the Socratic method. At least they were at Hemlock. Most law schools do that, which is where you're sort of cold called in the middle of class to answer certain questions or give your thoughts on the reading. I'm very far away from this now because my first year of law school was, like 15 years ago, and I am not in the academic setting now, but it differed in that you were definitely more on the hot seat, and certain professors did that more than others. But that's definitely the first year experience, and then the second and third year experiences were, I would say, more similar to undergraduate classes. There were, we had more discussion seminars, and even the non-discussion seminars, the ones that could have been Socratic method, were reined in a little bit more. But then there were also just way more, for me at least, clinical experiences where you're doing real world work, supervised by attorneys, and that sort of thing.
Sure, Professor, just add one thing. It may seem difficult at first, but that's because they're teaching you a new language, right? You're learning a whole new language of how to understand it and read it. And so at first you may be kind of just a little lost because they're throwing so much at you, but eventually it all clicks and then it's just easier going at that point.
Yeah, I would agree with that. The first year, there is some, to varying degrees, use the Socratic method where you're on the hot seat. I would just say it felt like combat when I was a student. It was just terrifying. I mean, I remember that, like, please God, don't call on me. Please don't call on me. I still remember that, to this day. They are not, and especially now the professors, the important thing to keep in mind is they are teaching you a way of thinking. And they are teaching you to pick out the important information in the case laws and to extract that important information and to think like a lawyer. And so they're not trying to embarrass you. That is not the goal. The goal is to get you to think in that way that they want you to. So I just want, keep that in mind, like with the first year, don't let it intimidate you the way that I let it intimidate me. And it probably, it affected my learning experience to some degree because I was so intimidated by it. Understand what the methodology is and why they're doing what they're doing. And they're there to help you. I mean, it's supportive. Like, they want you to succeed. They're going to guide you, and they're going to help you through the process. And then the more you do it, the more, like, you're going to get the hang of it. And it's going to start, you're going to know what they're looking for. That's the whole idea of it in the process. I would say, though, that then again, I agree with that, like, in the second, in third years, it's less like that, and it is more of a kind of a discussion, Like in my American Legal History class, I'm not putting anybody on the hot seat in the same way that you get in first year torts, for example.
And the first year classes and the Socratic method will give you years of jokes to have with your friends. My friends and I still routinely text about things that happened in our first year Civ Pro class. So,
yep.
You make some of your best friends in law school, because you're going through that same experience.
How do you see advances in AI, like GPT and other large language models, affecting law? Because it's reshaping every other industry.
I mean, that's something that my office deals with literally every day. It's, different firms, I can only speak from the law firm perspective. Different firms have taken different approaches. Some take the we're embracing innovation approach, and others take the absolutely no way, no how. And mine is in the innovation approach. But AI is difficult because, well, first of all, it's not a human, and lawyers have real value to provide as humans. But also, client confidences is really, our utmost principle that we need to uphold. And AI, when you're putting client information into AI robots, that's hugely problematic in every way. So there's a lot of issues that are being worked out on the law firm end in terms of just how do you protect client confidences while trying to use these sorts of innovations. And then there's also the issue that's come up countless times where attorneys cite cases to judges in their briefing, and those cases don't exist because an AI robot just made it up. So, that I think reinforces that you really still do need attorneys, but there certainly is value that AI can provide in certain areas of the law. And I think that's something that smarter firms will leverage while still staying true to the principles that we need to stay true to.
Well said.
I mean, I would just say, add to that, at the law school, we're still grappling with the implications of this and how it's going to shape the education, but certainly at Villanova Law, there's a lot of attention being paid to AI, and although, as Ellen pointed out, the technology is not there yet. I mean, there are so many examples of lawyers getting in trouble because their briefs were inaccurate because they relied on AI. But yeah, at the law school, we're continuing to shape our education to recognize this new reality that we're confronting. So
I will add one thing. Sometimes, you can ask AI or ChatGPT a summary on this case, and it'll give you the wrong summary.
Yep.
And it might say Justice Alito wrote, and Justice Alito didn't write. And so be very careful on, using AI.
Sorry to shift the subject a little bit, but as someone who's trying to figure out what she wants to do with the rest of her life, I see more reports and articles kind of indicating that lawyers are either unhappy or demonizing the profession. So I guess my question is, as lawyers, how do you not only overcome that label, or how has being a lawyer made you happy and fulfilling as a human being and contributing back to the world?
That's a really good question. I am very happy as a lawyer. Again, I do think that it helped that I took the time off before law school to think about whether it was something that I really wanted. I also think, I always had really firm boundaries about when not taking on so much work so that I was going to be so stretched thin and couldn't function. It's tough when you're a junior associate at a law firm to have those boundaries, and sometimes you have to let them go a little bit, but I think that that's helped me in terms of my own happiness in the profession, is maintaining those boundaries, and then, if the firm wasn't going to respect them, I probably would have moved on. I'll also say it is something that I think a lot of firms are focusing on more now. I was at a conference last year and we had a whole presentation on lawyer happiness and how do you keep your people happy and, mentally doing well, and how do you support people who are having challenges. So I think it's something that the industry is definitely confronting and trying to deal with. And it's a weird area where I think the pandemic actually positively impacted it because, before the pandemic, I was in the office 5 days a week, butt in seat every day. And that's completely different now. When I first started at my firm, I was wearing a full suit every day. Now my office is a jeans culture. And those are very sort of superficial ways that, changes that have been made. But I think that they do provide some impact. And I think that it'll keep changing. But I do think it's at least something that firms are more focused on, but has to come somewhat from within too. You have to push for your own happiness in your career.
Make sure you're happy where you end up, right? This is gonna be your second home. You might spend more time here. With the change as a result of the pandemic, things shift with more remote working, but make sure you enjoy the people you're working with and the environment. I used to tell people that I used to interview when I was back at Troutman, every firm has a different personality. Every firm presents themselves differently. Do you see yourself at that firm? Can you coexist? Do you enjoy it? Because if the answer is no, then you've lost already. You're coming coming in with that perspective of just like, I hate it here. And there's gonna be times where you're just gonna have one of those days. I don't know, I used to be in those days where I used to have a hard time and be like, I'm done, I'm searching the web for another job, and then like 2 days later, I'm like, okay. You know, it's inevitable, especially at big law. You have a deadline that you have to meet. You have to work over the weekend, or sometimes you just make mistakes and you have to fix them, right? And it's just, it comes with the territory, but just what helps the most that I would recommend is really finding a place that you see yourself as being happy.
Yeah, I mean, just to add to that, I personally think when I've been miserable, and when I was miserable as a practicing lawyer is when I didn't believe in what I was doing and I wasn't passionate about the work I was doing. And so when I was, it was not work. I mean, and I think that that's the goal, you know, with whatever you do, whether it being a lawyer or another profession, but finding an area of the law that you feel that way about, where you're fighting for something that you believe in, whatever that is. And you know, I understand, like, maybe to some degree financial constraints may play into that decision-making process, but, you know, you can work for the government, and it doesn't have to be big law. Like, there are other arenas in which to practice law where you can make a really good living and have a work-life balance, maybe doing work that you feel passionate about. It doesn't have to be in one environment. You can go into politics. I mean, there's all kinds of things that you can do with a law degree that doesn't involve practicing law, but with, you know, being a practicing lawyer, there isn't just one route to that. And so I'm just a really big advocate. I think misery comes from doing something that you don't enjoy, and an area of practice that you don't enjoy.
Yeah, and just to add something, if you're miserable, transition. Go somewhere else, do something else.
Yeah.
Like, you're not stuck there forever. Go to a different firm, go to public interest. Just find something different. Also, lawyers understand this is an issue, so there's a lot of CLEs you can attend, or group meetings, resources to help lawyers kind of deal with the struggles that sometimes come with the field.
In regards to the admission process, thank you. How would you say law schools view history majors? Would it be more of a pro or con compared to other pre-law tracks, or is it really just the GPA and LSAT that matter the most?
So people come from various different academic backgrounds in law school. You do not have to be pre-law. You do not have to be political science. We have people who are art history, who are nursing. It really does depend on when you were in your courses. Were you challenging yourself? Were you just taking introductory courses? Or were you actually taking courses that helped you to really critically think and analyze and extract information and be able to put that in a very focused way in performing in that classroom? So there's not a favored major. Most people are political science majors who apply to law school. When I first started 14 years ago, about 10% of our students or applicants were history majors, including myself. I didn't go to law school because I was too empathetic and I was afraid that I wouldn't be able to draw those boundaries. So I ended up working for law schools. But I was a history major myself, and so I could kind of see where it was trending. It goes up and down every year. It really is going to depend on your performance in those courses, and you can really see if somebody's enjoying their courses in their major versus people who are feeling obligated to take a certain course kind of direction, with the aim of attending law school. So it's not a plus or a minus or a pro or con. It's more of how you perform in the course, I guess, major that you select. And that's even for the graduate level as well.
I will say it fluctuates. When I was looking at law school, I did some research, and research is important. Again, it changes every year, but English was the #1 degree going into law school, and then history, and if I remember correctly, it was poli-sci after that. I'm sure, again, it changes year to year, but just for context.
Any more questions? No? All All right, well, I would like to thank our three panelists for an excellent discussion.
And everyone, we have a little reception outside, and so I invite you to partake in some refreshments, some beverages, and continue the conversation. Thank you, and thank you for coming.